Good morning, Alta Realty Group agents. This is Kevin Lauren, I'm the Director of Training and Marketing here, and I'm joined by Bill Seitz. Good morning, Bill Seitz.
Good morning, Kevin.
How are we doing today?
Good. How are you doing?
All right, doing okay. And let me bring Travis Breton, our corporate broker, on. Good morning, Travis.
Good morning. How's it going?
Good. All right, cool. So today we're going to be talking we've got a great presentation. We're going to be talking about the Seller Property Questionnaire. So really good info. Travis is going to take us through that. But before that, let's go ahead and Bill, we've been on a wild ride with Treasury and rates, all that kind of stuff. Maybe just bring us up to speed real quick.
Yeah, well, we've entered uncharted territory.
Totally. Absolutely. Cheapest money ever.
We have fallen off the mortgage cliff.
In a good way.
As you can see right there.
I know, it is a cliff. Goodbye.
After about February 15th or so, it has just gone absolutely bottomed out. And some think there might be even a little more downside. Even today, it's down 6 basis points.
Wow, look at that.
Obviously, there's a lot of volatility with what's happening in the market and happening with the coronavirus. I think we talked about that a little bit last week.
Yeah.
And well, hold on, Kev.
Yeah, no problem.
1 second here.
Yeah, literally below 1%. This is insane.
I have a really weird background noise on my my headset right now. I don't know what that was.
Okay.
That was like the most bizarre thing. Sorry. It was one of those situations where I don't know, I have another window open in the background and I just got blasted with like a commercial or something.
All right, you survived. You're going to be okay.
Yeah, I survived. Okay, now we're back. Sorry about that, guys.
That's okay.
That's one of the moments where if anyone's had that happen to you, you feel like you're going crazy because you're like, wait, I'm talking to people and now there's a commercial on in the background. I don't know how to get rid of it.
Right.
Anyway.
I could go on a tirade about websites and about not having sound on your website, but that's for a different webinar.
But yeah, so I apologize there. That was bizarre. Yeah. So anyways, we're definitely in uncharted territory with the situation. Obviously, shows opportunity, right?
Yep.
Actually, yesterday I had a pre-approval out for one of our Alta agents, and he, was aware of the rates coming down. Rates were probably about 0.5% higher when we had done the pre-approval, and he had just said, "Hey, can you rerun it now based on where interest rates are today to see what they can afford? How much more can they afford?"
Yeah.
So we actually were able to bump up the purchase price about $50,000 from $350 to $400 based on where rates are today. So
that's incredible, Bill. I mean, that is literally real purchase power based on market rates. It's incredible.
It is. And the good agents will take advantage of this, pick up the phone, call, say, "Hey, let's move, let's jump. You've been thinking, now's the time." Create the opportunity and be the expert and show your clients that you're on top of it and you're literally on top of it. So this is kind of the situation here we're having right now. And I encourage all you guys, if you have someone on the fence, maybe they have a property that they were thinking about getting an investment property. Maybe they want to leverage that into a new opportunity. It really is. I mean, can't emphasize it enough. It is really cheap money out there. And I think I priced an FHA loan out 2 days ago, and it was below 3%.
Yeah, you were telling me that
2.875, I believe it was for.
I literally have that written down on my pad here.
Yeah,
I was freaked out about it. Yeah, 2.875, 30-year fix. Wow.
So we're in good territory, guys. This is really going to keep the economy, or at least the housing market, strong. As things kind of develop here. So. Get out there and take advantage.
Yeah, and the other thing is, you're being a good agent to your sphere of influence by reaching out to them in your newsletters or, however you're going to do it, and reminding them, hey, I sold you a house, 6, 8, 9 months ago, a year ago. If you haven't refinanced, let's take advantage of it. Just reminding them or providing that value. So not a bad idea as well.
Absolutely. And then real quick before Travis jumps in, Kev, I just wanted to, just a couple housekeeping items. Number one, please, if you're working the Op City leads, please make sure you keep those updated and keep those referrals current, so you don't lose your ranking and the quality of the leads you're getting.
Yeah.
We have a number of agents doing that effectively, and it's really good to see. And also, if you get a transaction, a listing, a new buyer deal goes into escrow, those need to be uploaded immediately upon a signed contract, new escrow. We're seeing stuff coming in, a couple days before closing, and that's not good.
No, it makes it near impossible to really supervise the file properly. So we want everybody to be, in compliance, and just making sure that we're able to help and make sure that is in our SkySlip system.
100%. I think Travis will reiterate that as he comes on board here. But if we can't supervise the file, or at least be looking at it, the BRE is going to say, how do you guys supervise your agents? And it behooves all of us to do things in the proper fashion. And if you're using outside TCs, I know that we have one internally with Kaylin. I think Travis has a gal that he's referred out to some of the agents. If you're using an outside TC, it's also your job to either have them contact one of us and so they know the system, or you need to tell them, hey, those contracts need to be uploaded immediately upon acceptance or upon a new listing agreement.
Yeah, and obviously at every step of the way, so we can properly supervise the files.
Correct.
Correct. Correct, Amundo. All right, great. Well, thanks, Bill. Always appreciate your insight into mortgage land and other things.
Of course. I'll be listening now.
All right, good man. All right, Travis. Well, I've got our Mind Your SPQs up, so take it away, my friend.
All right, so I put together basically just a little slideshow here to go over the SPQ, clear up questions. It's kind of in a Q&A type format, but it should, answer a lot of questions that I get, I wouldn't say daily, but questions I get on the SPQ and what documents, are needed per different file that comes in, basically. So this is what we're going to talk about today, is the SPQ.
Thanks, buddy.
So first up is, what is the SPQ? The California Association of Realtors Standard Form SPQ Seller's Property Questionnaire is a document designed to help sellers disclose information about the property's condition that might affect a buyer's decision to buy. Is the SPQ required to be used in real estate sales? Yes, depending on which purchase agreement is used. While no law or statute requires sellers to use this form, the pre-printed language in the CAR form, the RPA that we're using, and other residential contracts requires use of the SPQ when they are required to use the TDS. So what's that saying? It's not a law that we have to use it, but it's contractually bound that it is used.
Right. Okay. So we have a couple of agents that are new on the line, so I think that's really helpful.
Yeah. So the purchase agreements that require delivery of the SPQ are the RPA, the mobile home RPA, the notice of default, and the RIPA. So the vacant land purchase agreement does not require delivery of the SPQ, but it does require delivery of a similar form called the Seller Vacant Land Questionnaire. However, the SPQ is not required by law, only contract. Thus, if a seller did not want to provide the SPQ, then the language in the standard residential purchase agreements would have to be amended, typically through a counteroffer. So if the seller is not wanting to provide this, we need to state so in a counteroffer is fine. You could do an addendum too, but it needs to be stated in there that the seller will not be providing the SPQ. Buyer needs to agree to that and sign off on it, and that protects everybody.
Got it.
From having it in the file, basically. Yeah. So in the residential purchase agreements where SPQ is it required even if the property is TDS exempt?
And also just want to remind everybody, we do have a question, and I'm sorry, we do have a chat feature. So if there is something that comes up while we're going through this, don't hesitate to put your question in the chat, and I will make sure that Travis answers that. Go ahead.
Okay, can you just go to the next slide?
Yes, I can.
Wait, Travis, I have a question for you.
Yeah.
The TDS exemption is usually for people who they maybe own the property, or they, let's say, maybe the property's in a trust. They never lived in the property, right? They don't know anything about the property. They can't really give a statement about the condition or about what's gone on in the home because they've never lived there, or they've never spent any time in the property. And they say, hey, I'm exempt from this. I don't know anything about it. And that would be a situation where this buyer would say, I understand you've never lived there, but I'm buying this from you. Is that correct?
Yeah. So, and just because it's in a trust doesn't mean that it's TDS exempt. So that's also a misconception.
What is the criteria?
If anybody who within the trust has lived on the property within the past couple of years, it is not TDS exempt. So you have to, if there's, 3 siblings who are within the trust and they're going to be, receiving funds from the trust, and one of them maybe has been living there. I run into this a lot, actually. One of the siblings is living in the house, rent-free or whatever. A TDS is going to be required on there because that sibling has knowledge of condition of the home.
And that's super important, especially if we're taking listings with people that have trusts, or that are maybe have one person that does have that knowledge, because that's an opening down the line. Something happens, you didn't advise your clients correctly that they had to sign it, or you didn't think they did. There's an opening there for some liability.
Yep, there could be. So, all right, so moving on. So in the residential purchase agreements listed in the previous question, the SPQ is required only when the TDS is also required. So good rule of thumb, if you're filling out the TDS, the SPQ is also going to be required unless otherwise stated in a purchase agreement. So in other words, if transaction exempt from the requirement, then the SPQ likewise is not required. So just make them go hand in hand, basically.
Yeah.
I noticed there's a lot of overlap on those two forms anyway. There's a little bit of redundancy there, but I guess.
Yeah.
But I guess that's just the way it goes.
Yeah, exactly. So what types of properties are not covered by the TDS? The TDS law applies to transfers by sale, exchange, installment, land sale contract, lease with an option to purchase, or ground lease coupled with improvements of real property, improved with 1 to 4 dwelling units. In addition, it applies to resales of manufactured homes and mobile homes classified as personal property intended to be used as a residence. The TDS law does not apply to residential properties of 5 or more units, commercial, industrial, vacant land, or agricultural property.
Makes sense.
Yep. And if you want to refer to the civil code, it's there.
There you go.
There it is. I'm going to read up on it.
Right.
Are there any transactions involving 1 to 4 unit residential properties for which the seller is exempt from providing the TDS? Certain types of transfers are specifically exempted by California Civil Code 1102.2. These are as follows. So transfers requiring a public report where no public report is required. Transfers pursuant to court order, such as court order probate sales, sales by a bankruptcy trustee, writ of execution, eminent domain. and transfer resulting from a decree for specific performance. Transfers by foreclosure, including a deed in lieu of foreclosure, and transfer by a beneficiary who has acquired the property by foreclosure or deed in lieu of foreclosure. Transfers by a fiduciary in the course of the administration of descendants' estate, guardianship, conservatorship, or trust. Note on that, an exception to this exemption occurs when the property is held in a revocable trust and the trustee is a natural person who is also either the former owner of the property or was an occupant in the possession of the property within the year preceding the transfer.
All that criteria makes a lot of sense.
It really does, actually. Transfers from one co-owner to one or more other co-owners. Transfers made to a spouse or to a child, grandchild, parent, grandparent, or other direct ancestor or descendant. Transfers between spouses in connection with the dissolution of a marriage or similar proceeding. Transfers by the state controller pursuant to unclaimed property law. Transfers as a result of failure to pay property taxes. Transfers or exchanges to or from any government entity.
Sorry about that.
So even though the seller of residential 1 to 4 property may be exempt from having to provide a TDS in certain situations, a licensee is not exempt and must conduct this inspection and disclose the results of the inspection in almost all residential transactions involving 1 to 4 units. What we're talking about there is the AVID. That is a requirement. CAR form AVID may be used by the real estate licensee for this purpose. Realtors should review the legal article, real estate licensee's duty to inspect, for additional information. And you can find that in CAR.org. There's a lot of information about that kind of stuff. And they have an article in there about it.
That might be something to touch on at a later date, Travis, because I think the AVID is something that agents weren't required to do in the past. I know that going back several years, there was never an AVID, right? You never had to fill that out, time, date, weather, basically barometer check on the atmosphere.
Yeah.
But, I think people just kind of put in the bare minimum. But once again, the more you put, the more you show that you're a competent agent and that you're actually noting down whether there's dry rot on the eaves, dry rot on the exterior. There's evidence of some spots in the drywall. Whatever it is, you're not trying to kill the deal, but at the same time, you're showing that you are a competent realtor looking for these places in the home, in the transfer process, and that you are a professional that does this. You know what I mean?
Yeah. On that tangent. So what I've been told is for your AVIDs, consistency is key. If you were to, ever face a judge, that consistency in your AVIDs and how you perform them. Are you noting the same areas of the home each and every time? And to make note of something in every room, basically, a tear in a screen, a scratch on a wall, missing baseboard, all those types of things. And also to note, if you're walking down a hallway, which bedroom are you referring to? Well, it's the one at the end of the hallway or the one at the end of the hallway on the right, or, make notes so someone could actually tell what bedroom you're talking about and not just bedroom 2.
Yeah, that's a really good point, Travis. Perhaps every agent needs to have a, kind of like a step-by-step that they do each time they, so there's there's always a guideline that they follow. That way, exactly like you're saying, if anybody came back and was analyzing that, it's like, hey, I have a checklist, I have a step-by-step thing that I do every time. That would go a long way.
Yep.
And you can always find things that are wrong. I don't care if the home is a brand new build. I know I can go in and look at a home that's been just completed by whatever KB Homes or Toll Brothers, and I can find things that are done sloppy, or there's always something to be noted. So don't think that, oh, just because, you're just trying to get by with the bare minimum. That's, I think this is something that you really need to be mindful of and show, you're not going to kill the deal. Your buyer, if they truly want the property, they're going to go through with the transaction, but you're protecting yourself from any future issue or competency in the eyes of, like Travis said, a judge or a arbitrator or litigation or whatever, should something go down the line.
Yeah, well said.
You're not going to kill the deal any worse than a home inspector.
Check.
Yeah. So if the transaction is TDS exempt, then how does the seller disclose material facts? Where the transaction is TDS exempt, then the seller should fill out and deliver to the buyer Form ESD, which is the exempt seller disclosure. Per the terms of the contract, TDS exempt transactions must use the ESD. While there is no law,
Sorry, buddy.
Sorry. While there is no law or statute requiring the use of this particular form, the pre-printed language in the CAR, residential purchase agreement, and other residential contracts does indeed require the ESD when the transaction is completed. Does the SPQ replace the TDS? It does not. The SPQ does not replace the TDS. In fact, every CAR purchase agreement where the TDS is required, the SPQ is also required. It's given in addition to the TDS. Does it replace the SBSA? No, SBSA, a form created by CAR, is an optional risk management form. It is a recommended form that may be used in every transaction. However, it is never required by law. If the SBSA is given to either the buyer or seller, it will be in addition to the SPQ and not in lieu of the SPQ.
What's this? Is it SBSA, the statewide buyer thing?
Yeah.
Yeah.
Do you recommend it?
About disclosures?
That's the 12-page
Yeah.
novel.
Yeah.
Okay.
Got it.
Which provision of the RPA requires the delivery of the SPQ? So here's a snippet of the RPA, and you'll see in paragraph 10A, number 4, down there at the bottom, it says within the time specified in paragraph 14A, seller, unless exempt from obligation to provide TDS, shall complete and provide buyer with a seller property questionnaire. If seller is not required to provide a TDS, seller shall complete and provide buyer with an exempt seller disclosure. So
there you go.
Right there in the RPA, black and white, you got to provide it.
There it is.
Nice feature.
Nice feature.
Yes, indeed. Nice word.
Yeah. When should the SPQ be completed and delivered to a buyer? The RPA requires by default that the SPQ be delivered within 7 days after acceptance along with all other disclosures. So here's another snippet of our RPA, 14A. This is where you're providing all the disclosures within 7 days unless otherwise specified.
Okay.
What rights does the buyer have as a result of receiving the SPQ? Depends on when the SPQ is given and the language of the contract. If the SPQ is given to a buyer before the offer is written, then a buyer can take the disclosure into account when deciding whether or how much to offer for a property or what request to make of a seller during the inspection period. If the SPQ is given after an offer is made, but during the buyer's inspection period, the buyer can take the disclosure into account when deciding whether to make requests of the seller before expiration of the inspection period and whether to remove an inspection contingency or cancel the contract. The SPQ is given after the inspection period has already expired and after a TDS has already been delivered. It can be considered a material amendment to the TDS or a subsequent or amended disclosures pursuant to the contract, triggering either a statutory right of rescission or contractual right of cancellation, even if the buyer has removed their contingency. So what that says is if the seller it gives you this SPQ, a week after the TDS and everything has already been delivered and you've released contingencies, well, this opens it back up again because it's a new material fact.
And it's an additional 5 days, right?
Yep.
They have to review the document?
Uh-huh.
Mm-hmm.
Or whatever the contract has stated, but it's default 5 days.
Right. If they haven't provided it within 7 days of the seller obligation to provide, within the first 7 days of the initial timeline, they hand deliver it on the 10th day, you get 5 days from the date of delivery to review the document, correct?
Yep.
Got it.
How does the SPQ help the buyer? Because the SPQ may trigger a seller's memory about the property and prompts the seller to disclose information, the buyer who receives the SPQ is likely to have more information about the property than the buyer would have otherwise received if the SPQ was not used. The buyer can then take this information into account when deciding how much to offer for a property, what types of inspections to have, what kinds of repairs to request, or whether to seek other adjustments to the contract and whether to remove contingencies or cancel the agreement. How does the SPQ help the seller? By providing a more thorough disclosure, either before or during a transaction than may have otherwise occurred, the seller reduces the possibility for misunderstandings with the buyer, and even worse, future claims or lawsuits by the buyer alleging the seller misrepresented the property, intentionally failed to disclose material facts, or committed fraud.
Very important.
Yeah. Often, the anger that accompanies an after-close discovery aggravates a situation that could have been easily resolved prior to the close of escrow.
Amen to that.
Right. Disclose, 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 right?
Uh-huh.
How should an agent respond if seller asks the agent if a particular item warrants disclosure in the SPQ? As a general rule, one can say, when in doubt, disclose. If the seller believes the item is important enough to ask the question, then disclosure is the prudent thing to do. If it turns out the disclosure is not important to the buyer, then it will be of no consequence. If the disclosure is of concern, it's better to resolve the matter prior to escrow closing rather than risk a later argument or lawsuit on whether disclosure should have been made as a material fact. Does the form prompt the seller to disclose defects that have been repaired? Yes, see section B, seller awareness, subsection C, that states including past defects that have been repaired. So this is actually the SPQ form we're looking at here, or a snippet of it. And it's asking, are you, seller, aware of? And then it goes into C1 there. It's asking if you're aware of any of those items there.
So if you had a slab leak, you had a failing electrical panel, you click yes, and you go down to your explanation. Slab leak 2005, repair, and there you go.
And that's it. Yep. How far back in time does a seller have to make disclosures? This is always a fun one. The seller should answer the questions based on the seller's actual knowledge, regardless of the time involved. The seller can always specify at time as part of the explanation. Ultimately, only a judge or arbitrator hearing a dispute can decide whether the item is no longer material or significant because of the passage of time. A disclosure avoids the issue. If there's ever a question, remember, the state of California wants the buyer to know everything the seller knows. And that's the rule of thumb that I always go by, and that's what I always tell my sellers when they're asking this question is the state of California wants the buyer to know everything you know. So if you know it, then we should disclose it.
Good rule of thumb.
Does the seller have to disclose items that occurred before the seller acquired the property? If the seller has actual knowledge, yes. The seller must disclose all known material facts. Once again, question, remember, state of California wants the buyer to know everything the seller knows.
Yeah.
So,
Can we be more clear?
I really, just fall back on that every time. If they're really not wanting to disclose something, it's opening up risk for everybody.
Yeah.
Well, you could imagine just the previous scenario where, let's say I bought a property from Kevin. Kevin disclosed something to me. I bought the property. I fill out my form, give it to Travis, but I don't put on the form what Kevin told me, because that was before I took ownership of the property or you actually lived in it. So it doesn't stop when the day you get your keys to the day you sell the property. It's anything that you may know of happened before, or it could be 2 people down the line that you knew something happened. Maybe they buried a horse on the property. I don't mean, who knows, but that's the reality. And if you have a material fact and that'll affect the buyer's decision to make that purchase, you better disclose it.
Yep.
There's no horse on the property, by the way.
Hey, I actually sold a house. The guy did that.
That's just weird.
Yeah.
But hey, it's exactly the kind of stuff that can be.
Yeah, it was out there in Orange Park Acres, the big, huge lots, and the guy was, had horses and chickens and all sorts of stuff, and he just illegally buried his horse on the property.
Jeez.
But hey, you've been in this business long enough, you got stories.
Oh, baby.
Oh, yeah, we all have them. Yeah. Jeez. Does the SPQ require the seller to provide certain documents pertaining to the package? Yes, the last question of the SPQ asks the seller to turn over copies of reports, inspections, disclosures, warranties, maintenance recommendations, estimates, studies, surveys, or other documents pertaining to the condition of the property. Essentially, the SPQ requires practically any written item pertaining to the condition of the property, let's say that, to be turned over to the buyer. So here we are, we got a snippet again. It's asking, are you, the seller, aware of? And then it's asking any reports, inspections, anything like that. So basically any paperwork the owner has on the house should be turned over to the buyer for inspection.
So if he had a tree removal estimate on a massive tree in the front yard that may be affecting the plumbing or could possibly be an issue, you should bring that out and show that to the buyer.
Yep. And I've seen some sellers are really good about it. They'll literally hand me a 3-ring binder full of stuff, and you think it's silly, but it's not.
Oh,
and
that's
actually,
smart.
buyers really appreciate it most of the time.
No, very smart.
Yeah, it just shows you the kind of the diligence that the seller had while owning the property.
Yep.
Good sellers.
So does this SPQ represent an absolute description of the current and future condition of the property? No, the SPQ is only asking about the seller's current knowledge. The question is framed as, are you, the seller, aware of? If the seller is not aware of an issue, then the answer no. The SPQ is not a guarantee of the property's condition, not a warranty regarding its future status, and not a promise that the seller is either aware of or remembers everything that is asked. Rather, it represents a snapshot of the seller's good faith recollection about various aspects concerning the property. A buyer should consider the SPQ as one item affecting the buyer's decision. It's not a substitute for the buyer's own inspection, judgment, or comment. Does the SPQ replace other seller disclosure documents that may already exist in certain markets? In many markets, local association of realtors or brokerage companies or both have created their own documents, either addenda or the purchase contract or TDS, to elicit additional information from the seller. These association realtors and brokerage companies believe, as did the CAR Standards Form Committee when it recommended publishing the SPQ, that it's beneficial for both seller and buyer if information is disclosed during the course of the transaction. Such disclosure helps prevent misunderstandings and allows for an open, honest, good faith discussion between buyer and seller. Having knowledge of the availability of other disclosures in use throughout the state, the SVAC recommendation was also based partly on the belief that the statewide standard disclosure can help create consistency among transactions and real estate firms. Whether locally generated documents are replaced by the SPQ or modified as a result of the SPQ depends on management philosophy, attorney input, and members or licensee input to the local association or brokerage company. So we don't have a replacement disclosure for the SPQ. Therefore, the SPQ is a required disclosure to be executed by both seller and buyer. Additionally, our policy, our E&O policy, requires forms to be CAR forms. So if another brokerage out there is providing something that is not an actual CAR form SPQ, it could jeopardize E&O coverage. So that's something to keep in mind as well. And I'm not saying disregard their disclosure, but I would ask for the actual disclosure to either also be made on the SPQ or in addition. And that's at the end of the presentation. Then.
Hey Travis, real quick, do you like to advise? I remember when I first started in the business, I was always, when I got the listing, I was always just so excited just to get the listing. I wouldn't have the seller fill out the disclosures, at the beginning. I kind of was the guy just flying around, just kind of like,
We're excited.
Yeah. And not having good habits in place, and really getting all this stuff front loaded on the front end, because as I already know what you're probably going to say, but just want to hear it from you. Getting this stuff up front is so much better. So when you do get the offer, you're not in that situation where you're delivering these disclosures after the 7 days. You get it to them right up front, which preserves and saves time. If there's ever a cancellation, you're not wasting more time than there needs to be, and you can make this just a more efficient process.
Yeah, so it's kind of customary in different markets. In some markets, this stuff is requested prior to an offer being made. I know that can be a little customary up in the northern area. Before an offer is even made, they have SPQs and TDSs and all that fun stuff ready for the buyer to look at and basically sign off on, Me personally, I'm like you in the sense that, depending on how long the listing appointment goes, maybe it's already getting long, the sellers are getting tired. I get the contract signed, and then I follow up with that with a disclosure package later. And there's some good online sources out there these days. Glide is coming around where you can, do this kind of stuff online with your sellers a little bit better, a little easier. So you can just send them a package later and have them all digitally filled out. And it makes it a little bit easier to get this stuff filled out, because sometimes, you have this huge packet of disclosures, and you're going to sit there for another 45 minutes. I don't really want them to feel pressured that I'm still in their house waiting for them to fill out these disclosures and whatnot.
Right.
So I get the contract signed. I tell them, hey, pictures are, the photographer's coming over on Tuesday, be ready. And I'll either bring disclosures then for them to fill out, or I'll send them to them, electronically. It just kind of depends on my sellers and how they are with that stuff. But I actually don't do it at the listing appointment.
Yeah, that makes sense.
Yeah, I like them to take time, and I tell them, read everything, disclose everything. I tell them, state of California wants the buyer to know everything so just take your time, try and remember everything. That way there's no pressure.
Yeah. Kev, is there any questions?
I don't see any questions in the chat. However, I'm sure as the agents digest this stuff, there probably will be questions. What I'll do is when I put out the replay, I'll make sure that I put a copy of the slides into the replay, so you guys can have that as well.
Yep, and then always, everybody has my phone number and email, call or text, email, anytime.
Absolutely.
Yeah, it's a good refresher course. I mean, I think, as I'm not selling as much real estate anymore, just because I'm working a lot of the finance stuff, it's just even good for my own brain, my own knowledge to be constantly updated, as it is with all of us, of why we do the things we do, why these forms are put in place, and how it protects yourself and the brokerage. So it's good stuff.
And allowing you not to get bullied around. Sometimes there's misconceptions on the other side of the other agent in the transaction. Sometimes they may have false information, and if they're saying, oh, SPQ is not even legally required, well, we just showed you the part of the contract that says it is.
Actually, I think I've heard that before, actually, a few years ago. Someone was trying to tell me that.
Exactly. So, well, it's not, but it is for this particular contract. So.
Well, and for the E&O policy, I mean, that's something that I learned right there. If your E&O policy is null and void because you didn't put the right form in there, that's a big problem.
Oh, yeah.
Look, they're going to find a reason not to cover it, and so just use CAR forms because they all want CAR forms.
Mm-hmm.
Oh, cool.
Yep.
Perfect. All right, guys. Well, thanks for being on the webinar. Travis, Bill, thank you for your insight, and look forward to next week. You guys get out there, make it a productive week, and we'll see you next week on the webinar. Bye-bye.